Hello, everyone. It's noon. We are live from the Carpenter Law Firm studios, my office. We have moved our office to Gilbert and Germain in Gilbert, Arizona. And I'm happy to be presenting today on, is housing fair yet? We've been on this journey since the mid-60s, and we'll talk today about the goal, the aspiration, and the destination, whether we're there yet. And thank you for your indulgence. The court called on our previously scheduled date for this seminar and said we need to reschedule a previous hearing, and it was on the date of this seminar. So I appreciate your indulgence. It was scheduled from 9 to 12, downtown Phoenix. I knew I couldn't be back in the studio at noon. And of course, it went longer than even noon. So I appreciate this opportunity to conduct this rescheduled seminar. This word fair housing is frustrating because my experience with fair housing, going back to when I started in 1994, does that make me old? I don't know. We'll see. Is frustrating because my overwhelming experience with fair housing matters is that my client, the association, the board members, and often the professional community managers feel that it's unfair. The burdens created by fair housing law create pockets of unfairness. The question being, what is the fair outcome? And does it have to be a zero-sum game? Zero-sum game being I win, you lose. There's a winner and a loser, and that the tug of war is that when one side gains, the other side loses. When there's an advantage, there's always a disadvantage. When I gain 2 feet, you lose 2 feet. And that's how it feels often. And so the first frustration with fair housing law, fair housing matters, is that it feels unfair. If we're talking about a group home, if we're talking about animals, if we're talking about hostile housing harassment, it feels unfair. So when we even utter the words fair housing, we start with the disadvantage that for a lot of people on our side, the community association side, the board of directors side, the professional community managers side, it often feels like we're talking about unfair housing. So let's go through it here. Why the word fair? The home itself is neutral. The structure, the abode, the condominium unit, the single-family home, the home is neutral. The fair or unfair is about something different. So let's ask ourselves the question, back when the Fair Housing Act was enacted along with the Civil Rights Act in the mid-60s. Some of us were around back then. I wasn't born until the tail end of the 60s. Mental calculations, how old is Scott? Well, I'm not going to say, but I was born in the 60s. So I'm 50-something. What does the law expect to be fair? It really boils down to access and treatment. That's the fair part of fair housing. How do people access their abode, and how are they treated? And this applies to all housing, whether it's apartments, which we call multifamily, or condominiums, or single-family homes. It's about access and treatment. And when I say access, I don't just mean wheelchair access or blue button access. By the way, I like blue buttons. In my new office here at Gilbert and Germain, when I'm carrying a bunch of files into my office, or yesterday, my favorite lamp, I need the blue button. And it's not because I'm in my 50s, it's because my hands are full. We all like the blue button from time to time. Whether we're disabled or not, the blue button can be good. Our hands are full, groceries, bags, backpacks, briefcases, lamps, junk, whatever. The blue button is about access, originally for the disabled. But sometimes we swing our hips around and we try to get the blue button because our hands are full. So access is not just about getting in the building or getting in our home or getting into our condo or apartment. It's also about sales. It's about accessing the home that you want. It's about racial lines too. Back in the 60s, this was about making sure that all housing was available to people of all colors, that purple people and orange people and red people and black people and brown people could all have access to all stock of housing, from this side of the tracks and that side of the tracks, the north side, the south side, the west side, the east side. But once in the house or apartment or condo, that everyone's treated the same. And so it's about treatment and access and sales and rentals, everything else in between. So it's also about the structure. We've heard this before. It's about the ramp to get into your townhouse, the ramp to get into the clubhouse, the ramp to get into the apartment, all of those things. That's also within the umbrella of access. And we also have this tendency that within fair housing, there's a people problem. Sometimes in condominiums, there's the old, well, I'm not sure that we want those people to be living here. What does that mean, those people? Well, it's all in the communicator who's saying it. Those people could be referring to gay people, could be referring to purple people, black people, brown people. It all depends on who's saying it. What do they mean when they say it? What does it mean when I say we don't want those people living here? It could be people without legal status. That's sort of the issue of the moment. We don't want people living here who are not legal immigrants. I heard that one the other day, and it's the first time I've heard that one in my years of practice. I've never heard a client say, we don't want people living here who do not have a legal right to be in the country. It's the first time I've heard that one. We have bad people with attitudes and behaviors and comments. By the way, national origin is a protected classification. So when someone says, we don't want people living here who are not in the country legally, it's not clear, not entirely clear under the case law, whether that would be protected. But national origin is a protected classification. So if someone who is not here with legal status were to say, well, I'm being discriminated against because of my national origin, that claim might work, even though they're not in the country with legal status. Although the association would say, or the board member would say, well, I'm discriminating against the person because of their legal status. I concede that. But the resident might say, well, I'm being discriminated against because of my national origin. I'm from Cambodia, let's say, and I concede I don't have legal status. I'm not a legal immigrant, but I take the position that I'm being discriminated against because I'm from Cambodia. That's my national origin. That would be an interesting lawsuit. And foreigners do have access to US courts. So I don't know how that case would go. But I discouraged this board member from acting too much on the instinct of discriminating against those people because they don't have legal status. So the public policy is easier to understand if we view fair housing from the following perspective. This is the way the law is designed. So this is public policy plan design. If you've been involved in designing a health plan, the people who do that call it plan design. So if you think of public policy and statutes kind of like a health plan, this is the way we think of it in this perspective. The public policy is designed with this basic assumption. And it's easier to understand why fair housing is complex if we understand the basic assumptions behind the public policy. Why do the fair housing statutes say what they say, and why is it so harsh sometimes? Well, the assumption is that discrimination in housing is constant and pervasive by all housing providers. Now, you may disagree with that, and it's easy to disagree with it if you have an inner thought. And your inner thought is, I don't do that. I do not discriminate when I am a housing provider. I do not discriminate when I act as a professional community manager. I do not discriminate when I sit on my board of directors. I'm a board president, and I do not discriminate. I have people in my community from all walks of life. I have people in my community of all sexual orientations and gender identities. I have people in my community from multiple national origins. I have Canadians, people from Mexico, people from South America, people from Asia, Africa, and I treat them all the same. I swear it. I disagree with this statement that discrimination in housing is constant and pervasive by all housing providers. Some apartment complexes might do that. Some other HOAs in other states might do that. In fact, I can think of some states where it's probably true, because some states are full of people who discriminate. But I don't do that. So I disagree with the assumption that creates the public policy. It actually doesn't matter if you disagree with the public policy. The fact is, that is the public policy assumption that creates the public policy. It doesn't matter if you disagree with it. And in fact, it's even more important that we accept the fact that your belief about yourself is completely irrelevant to whether or not this statement is foundational to the public policy. It doesn't matter if it's true or not. It's what is foundational to the public policy. It could be false. Even if it was true in 1965, it might be false today. But it is the doctrinal belief that is foundational to the public policy of fair housing. Discrimination in housing is constant and pervasive by all housing providers. As I said, you can disbelieve it. You can say that's not true for me. But it is not debatable that this belief is foundational to fair housing policy in the US today. So it's not surprising that the Department of Housing and Urban Development The Civil Rights Division of the Attorney General's office believes that it's constant, that if they look hard enough, if the magnifying glass has the magnifier turned up high enough, they'll find it. Just a matter of effort, magnification, and just keep looking. This is what HUD says, a federal agency, a cabinet level agency, says on its website. The mission of our sub office at HUD for fair housing and equal opportunity, their goal is to eliminate housing discrimination, promote economic opportunity, and achieve diverse, inclusive communities by leading the nation in the enforcement, administration, development, and public understanding of federal fair housing policies and laws. So their job is to enforce, administrate, develop, and help the public understand federal fair housing policies and laws. So they're active, they're on the front line, and it's all about, as I said earlier, access and treatment. And I say this with no judgment or ill will. They're true believers in this notion that the discrimination is constant and pervasive. So I'm not saying it's not true. I see a lot of accidental issues that come up from time to time by my clients, associations, boards, and managers, and all of a sudden everybody's in trouble. But they have to believe this. Either they believe it going in, or they take a job and then they become true believers. So here's what we can't do. Here's what we don't do as community associations. Generally, we are not renting or selling housing. This is where in the 60s, when the Fair Housing Act was enacted, this was a big deal. You've got to rent to everybody. You can't say in the 60s when we were fighting, civil rights, you can't say, I'll rent this house or I'll rent my casita, but no blacks. That was the stain of our country at the time. And the Fair Housing Act was enacted to say you can't discriminate that way. As community associations, we're not doing that. Generally, we're not renting or selling housing. But every once in a while, we do it. Imagine an association that forecloses its assessment lien, gets to the end of the case, and ends up winning the auction conducted by the sheriff, and then becomes the owner of the condo unit. After legal advice, the board decides, well, we own it. Let's become landlords. And I've had clients that have done that before. They foreclose on unit 18 because it hasn't paid its assessments. We get to the end of the case and the association wins the auction. The association becomes the owner. And instead of selling it on the open market, decides to keep it and become a landlord. Well, now we're renting. And we have to be careful that when we rent, we don't say, or when somebody comes in to rent it, say, well, we're not going to rent to you because we don't want any black or brown people. We don't want any gay people. We don't want any people with weird gender identity issues, men who dress up like women or whatever. That's going to violate fair housing. And then once we own it in this foreclosure, we put it on the open market. We have an open house and strange looking people come in, purple people, black people, brown people, obviously gay people, lesbians, people with weird gender identity issues, a guy who's 6'4" in high heels and a skirt. And we say, well, we don't want to sell to them. That'd be weird for our community. We can't do that. Neither can anybody else, actually. Not just the association, but anybody under fair housing cannot have an open house and whisper to their agent, I'll sell to anybody, but not those people, because they're all protected. Everybody I just mentioned, the purple person, the black person, the brown person, the gay couple, the lesbian couple, the 6'2" guy in high heels and a skirt, lipstick, all protected. All protected. And when they wander into the apartment complex sales office, all protected. All protected. We're not advertising housing either. But I've had clients also that the association decides they need to promote the benefits of living in Del Boca Vista, Seinfeld reference, and they invest money in promoting the community, whether it's in Iowa or Canada or the Northeast. They do put money into promoting the idea of living in community XYZ, Green Acre, Del Boca Vista, whatever you want to call it, for purposes of me making my point. And so that advertising has to comply with the fair housing regulations on advertising. Essentially, you can't just feature Caucasian couples, and there's other regulations as well. There are special rules for websites. It's a somewhat specialized area, and there are more regulations than you'd think. And having a balanced racial and gender makeup is important. So we don't actually advertise, developers and home builders advertise, but when the association does advertise, it has to be calibrated to be fair housing compliant. Generally, we're not evicting, but every once in a while we do. Loop back to number one. And when we evict, we have to be careful again that, let's say we own 40 units. We can't evict only the people. We have to be fair and balanced in the way that we evict. We can't, for people who have the same set of violations, we can't just evict the people. Sorry, we can't just evict people. We can't just evict the people who are protected. So we have to be careful again here too. That's redundant. I apologize for that. Generally, we're not providing mortgages. There are also rules about you can't discriminate to the way you provide a mortgage. But if we're selling in the first bullet point here, and we offer to carry the financing or rent to sell or something like that, we would have to be careful again that we're not discriminating in the way that we provide a mortgage. If in the first scenario, first bullet point, we end up owning the unit free and clear of a mortgage, and we then offered on the open market and offer to carry the financing, we would be providing a mortgage. So there's some scenarios where it feels like we're not providing certain aspects of housing, but every once in a while we would. So there are some potholes here on the road to fair housing that we can get caught up in, where there's some opportunities to trip over our shoelaces we have to be careful about. All right, let's talk about the two broad concepts, and a lot of fair housing traps can fit into these two areas. The first one is, excuse me, the reasonable modifications. Broadly speaking, the access part. And then the reasonable accommodations, the treatment part. Let's talk about the modifications first. The first one is modifications at the expense of the person requesting the modifications. This is roughly the disability issue. These may be on common area, on, in, or on units or lots. Think of this as ramps to units. Blue buttons on doors to clubhouses, grab bars in clubhouse bathrooms. And then there's the issue of moving parking spaces in a condominium. Let's go back for a second. Ramps to units. If the modification is entirely on a person's lot and it's in a planned community, there's no question that the expense is entirely on the lot owner, on the disabled person. The modification is on the lot, it's the disabled person asking, and the law says that the only limitation that the association can place on the unit owner is that it has to be reasonable. In a condominium, if the modification of the ramp is on common elements, then the modification still has to be reasonable. And if the person's disabled and they have a motorized wheelchair or something like that, the modification still is at the expense of the person requesting the modification. When it comes to blue buttons on doors to clubhouses, this is a tough one, and I've struggled with this over the years because I've had a number of cases where a disabled person ends up in litigation or in a disputed matter at HUD or the Attorney General's Office Civil Rights Division, and we end up in a debate about who should pay for the blue button at the clubhouse. And strictly speaking, under the law, it is possible for the association to take the position that the disabled person could be required to pay for the blue button on the door to the clubhouse. But I struggle. And I've had some difficult conversations with clients about this over the years because we're all aging. I made a joke about my age earlier, but today I'm a day older than I was yesterday. And tomorrow I'll be a day older. And a year from now, we'll all be a year older than we are today. Laws of physics, our bodies break down over time. Every single person in that association where the board said, make him pay for it, we have the right to do it. Every person in that association in 1 year is going to be 1 year older. And frankly, as I mentioned earlier, I used the blue button because my hands were full. In fact, I do it often, as able-bodied as I am. And I made the argument to my own client, despite the fact that they wanted to make the homeowner pay for it. I said, over time, everyone will use the blue button. It was a failure of the developer that they didn't put it in at original construction. You are an anomaly that the clubhouse doesn't have a blue button. And in fact, if the community had been constructed according to standard Americans with Disabilities Act guidelines, if you were built today, there would have been a blue button. But it was an older community, and they escaped that for some weird reason. And I'll mention where the ADA fits in a second. So the fact that they didn't have the blue button allowed this odd anomaly that the homeowner wanted it and they could make the homeowner pay for it. But I argued with my own client, which I tend to try not to do. I try not to do, not tend to try not to do. I do not do. And I said, over time, your homeowners will want it. Everyone's getting older. People use it even when they're not disabled for regular, normal reasons. And as I recall, the board decided to do it. They had other beefs with the homeowner. The homeowner wanted a pool lift at the pool too. And the case continued to be argued about other things as well. But on the blue button, the association put it in at association expense, but the developer should have done it anyway. So there's things like that to argue about. Grab bars in the bathroom would have been a standard installation if the community had been built according to normal ADA guidelines. Let's talk about the ADA. Fair housing has its own rules about reasonable modifications and reasonable access. The Americans with Disabilities Act requires reasonable accommodations to people with disabilities in public accommodations, public places, Walmart, Lowe's, Home Depot, hotels, shopping centers, malls, places that invite the public in. Our thing, clubhouses, condos, first floor lobbies of condos, those are not places of public invitation. It's not like going to the Hilton or Marriott or the Four Seasons or the Ritz-Carlton where the public is invited. The Americans with Disabilities Act does not apply to our thing. So when the clubhouse at the Blue Button place I just mentioned, let's call it Greenacre or Del Boca Vista, the Americans with Disabilities Act did not technically apply. Their new construction standards, the Americans with Disabilities Act, new construction standards did not apply. And so the Blue Button was not required according to the ADA's new construction requirements. Now, my office building that I just mentioned earlier, where I had the Blue Button, it's actually silver, but let's call it the Blue Button. When this building was built 3 or 4 years ago, a quarter mile east on Germain from Gilbert, south of the 202, a quarter mile, the ADA required, because this office building is a public building, required the Blue Button. There was no question that this building would have that button. But in a private HOA community, it was not required. So the developer didn't put it in. So now we have a situation where a disabled homeowner, a resident who was, by his own story, in a bad car accident and became a quadriplegic and is in a chair, wanted to be able to go to the clubhouse and enjoy the pool. That's why he wanted a pool lift at the pool. This was before that rule about pool lifts came into effect. And so we get into these debates from time to time. Same thing with the grab bars in the bathrooms. So, in my building here at the office, there are grab bars in the bathrooms because it's a public place. So some homeowners every once in a while misunderstand the difference between fair housing and ADA, and they use them interchangeably. And sometimes people know a little too much, not enough. And so they know the Americans with Disabilities Act, they throw it around. But we know that our thing is governed by the Fair Housing Act, and we are required to permit reasonable modifications at the expense of the person requesting the modification. But sometimes we'll do it at association expense if, as people age in place, we think it might need to be enjoyed by a larger number of people as they age in place, which is just pragmatism, frankly. Now, here's one that comes up from time to time that I think bears mention. Somebody in a condominium or a planned community says, well, I'm disabled and my parking space is too far away from my unit, or it's too far away from the elevator, the underground parking, and I want to be moved. I want my parking space moved to be closer. to my unit. I want to be closer to the elevator. And I hereby require a reasonable modification or a reasonable accommodation. They could use both terms. They might use both. They might use one or the other. And frankly, both of them are buzzwords. Don't get caught up in one or the other. And they say, I want to be moved. And they don't have to either, they really don't have to use one word or the other. They don't have to use both. They just say, I'm disabled. I'm too far from where I want to be. I want to be closer to my unit. I want to be closer to the elevator. Move my parking space. Frankly, this is hard. And on a scale of 1 to 10 for community association lawyers, I'd call it a 7 or an 8. But I'm going to tell you how we work through it. And it's tricky for some lawyers. I'll tell you exactly how we do it. I'm going to show you behind the curtain. So, not on the next slide. It's coming up though. I'm going to show you exactly how we do it. So here's HUD's position on prohibited modification requirements. Here's what we can't do. We cannot make people pay for liability insurance if there is a modification. We cannot make people comply with aesthetic standards. So if we tell people you can build a ramp, but it has to be painted and stuccoed, it can be ugly. HUD says if somebody's entitled to a ramp and it's ugly, that's okay. That's what HUD says. And we can't say to the homeowner, you can build a ramp, but you have to use XYZ Contracting LLC. That's what HUD says. And we can't say to a homeowner, you can build a ramp, but it has to be stucco and painted desert brown. This is what HUD says. And if they want a ramp, we cannot say to the homeowner, you can have it, but it has to comply with accessibility standard 4, 5, 6, 7. I'm making that up. But these are 5 requirements that HUD says we cannot impose on someone's requested modification for their home in terms of a disability. All right, here's my parking space reassignment. So here's how we lawyers do this behind the curtain. And this is what I'm telling you, this is the right way to do it. Some lawyers may do it the wrong way. This is the correct way. First is if the parking spaces are owned by the association in a planned community, the scenario is straightforward. The owner has a fair claim to space reassignment. So in a planned community, we'll get to a condo in a second. Planned community owns the parking spaces. The owner goes to the board and the board says, okay, you're in space 18. Bob's in space 45. You want space 45. We'll do a little parking space shuffle. We'll get Bob in here and we'll switch you out. Not particularly complicated. If the board does the parking space assignments, it's not that different than my new office building here assigning me parking space 57, which is my parking space. And I go to the building and say, hey, I just had knee replacement surgery. I didn't, but if I did, and I say, I'd like to have space 22, and they retain the right under the lease to assign parking spaces. And they go to the guy who's in 22 and say, hey, we're swapping you out with 57. Under a standard commercial lease in an office building, I don't know that either of us could complain too much. So we'd use that analogy here in a planned community. If the parking space is owned by a unit owner, such as it's on their deed, it'd be very difficult. In my scenario, the 22 space owner would have the right to be irritated that he's been evicted from space 22 in favor of the guy in 57 who wants space 22. So this happens from time to time in a condominium where I own unit 18 and I own space 22. And all of a sudden the board says, well, hey, disabled owner, you can have space 22, but the owner of space 22 produces a deed to space 22. And often what happens is the Civil Rights Division of the Attorney General's office, they think, because some of the investigators over there don't understand the complexity of this third bullet point, they think that a condo is assigning parking spaces just like an apartment complex, just like an office building, just like what I said with my space 57 and space 22. And what I just said about my office building is virtually identical to what happens at apartment complexes. Guy walks into the management office and says, hey, I've got a problem. I want to be reassigned a parking space. And the management office says, okay, I see you're on crutches. I get it. Let's reassign you. And they go to the person who's got the preferred space, preferred by the disabled guy, and they swap them out. And the management of the apartment complex says, well, the other guy might be irritated, but they figure he'll be irritated for a little while. But in America, people get irritated for a little while and then hopefully they get over it. But once the irritated person who's been relocated dives into the lease, maybe talks to a lawyer, probably doesn't, because that's how we are in America. We get irritated and maybe talk to a lawyer and then probably don't. Lawyers are expensive. What are we really going to do about it? Just because you have to walk a little further in an apartment, what's actually going to happen? How much money is someone going to spend over it? And so what ends up happening is management figures, okay, we've relocated somebody who's going to be irritated for a little while. The disabled person gets their preferred space. That's the correct result under fair housing law in the apartment. It'll blow over. But in the third bullet point, my point is that the Civil Rights Division of the Attorney General's office, they tend to think that in a condo, the board can reassign spaces just like that apartment complex. But when we run into this deeded right to space 22, the Attorney General's office doesn't know what to do. And they end up being wrong about it. So as a professional community manager, we have to be very careful about reassigning people in condominiums. And sometimes planned communities that look like townhouses that are not condominiums, to really understand what is the owner's relationship to the parking spaces when the parking spaces are numbered and people think they own the parking spaces. So we end up in this somewhat complicated realm where it's really all about bullet point number 3. Why do people think they own space 22? I own unit 18, but I always park in space 22, and I have for 20 years. Why? What paperwork do you have? Is it recorded with the county recorder? makes a big difference, actually. But the knee-jerk reaction of the Civil Rights Division of the Attorney General's office and HUD is that the condo, the management company, the board can reassign spaces just like the apartment complex can. And that's not always the case. Sometimes it's much more complicated. And I don't mean to disparage any of the other lawyers in the state who don't go through this process. What process am I talking about? Embedded in the third paragraph is figuring out how and why owners think that by owning unit 18 and always parking in space 22, how'd that happen? Why? Why do you always park in 22? What paperwork do you have? Why do you think you own space 22? I'm making it sound simple, but that's the key thing. That's what good lawyers do in this scenario, is figure out why the owner that's being kicked out of space 18, why does he or she think they have a right to park in space 18 forever? If I own it, the board and management cannot simply give my space to the disabled resident to be closer to their unit, to be closer to the elevator, etc. All right, let's talk about reasonable accommodations and HUD's position. Then this is the accommodation piece, not the modification piece. If an accommodation is approved promptly, the process is completed. And this is where things get a little more complicated. If an accommodation that's requested by the owner, if it's questioned or denied, there are more steps. And it's going to sound somewhat cumbersome, but it's really not all that complicated. If the accommodation is questioned, what's an accommodation? Well, an accommodation could be, my dog's over the weight limit, but it's an assistive animal. Accommodate me by declining to enforce your restriction. That's an accommodation. So if the accommodation that they want is questioned or denied, so the association says, we deny your accommodation, the accommodation is don't enforce your restriction. If the accommodation is questioned by the board must enter into an interactive discussion process between the housing provider. You are a housing provider. That term housing provider, don't get tripped up on it. The apartment complex is a housing provider. You are also a housing provider. An interactive discussion process has to occur between the housing provider and the person with the disability to explore whatever is at issue. Now, this can trip some people up because people wonder, well, what is an interactive discussion? Well, the easiest way to have an interactive discussion is to document an in-person conversation. And unfortunately, the disabled person is not going to be thrilled to go sit at a board meeting where the chairs are lined up, where the board is in a half moon and the homeowner is sitting in front of the board, and that's supposedly a interactive, fair, interactive discussion process where the homeowner is on equal footing with the board. I've been to plenty of those meetings, and unfortunately, where there's a board of 5 or 7 or more people, just based on the numbers, it's not an equal, fair, interactive discussion, because just based on the numbers, it doesn't work. So you can also have an interactive discussion with one board member and the disabled person and meet the requirement. So if ever we're going to question or deny an accommodation request, can't forget that there's a requirement to have this interactive discussion process to explore the issue. A lot of associations are not aware of or and disregard this requirement. And it's an important part of it because if it ends up in litigation, the fact that the association skips this becomes problematic. Sometimes the discussion is about whether the accommodation is related to the disability. Sometimes it's about the burdens of making a particular accommodation and the possibility of other less burdensome alternatives. I mean, the discussion could go any number of directions. And then ultimately, if the accommodation is denied, it must be because the accommodation would be an undue financial and administrative hardship or a fundamental alteration of the housing program. So there's some complexity here, but the most important part of this is that a lot of associations skip the interactive discussion process. If there's an accommodation that's requested, my dog is over the limit, under the limit, whatever the issue is, the board skips the interactive process before denying the accommodation, whether it's a lack of awareness of the requirement or awareness and then just disregarding it and then denying the accommodation. And some of the times it's not having the right lawyer on the team or just skipping over it, and then there's no documentation of the interactive process. A part of the interactive process too is to try to identify alternative ways to meet the needs of the disabled person with less burden on the housing provider. And again, don't get caught up in the words housing provider. On the association, a synonym for housing provider. It's not just about animals. It could be whatever the accommodation is. It could be accommodating an underage resident who's a caregiver for a 55 plus resident. We see that from time to time. The caregiver is 30 and everyone's required to be over 55 and the association's upset about it, or the caregiver is 20, 22, whatever, and everyone's supposed to be over 55 and the accommodation is to allow an underage resident. You can see how this would go. Ultimately, that may be denied. Probably shouldn't be, but sometimes it takes the guidance of a lawyer to get through this interactive process. Even if it's going to be denied, ultimately, we've got to paper the file, so to speak, so that if it ends up in litigation or if it ends up in an investigation with HUD or the Civil Rights Division of the Attorney General's office, we have the paper trail to defend it. But this interactive process is important to document how the association ended up at the decision. This is what the accommodation involves under federal law. It is unlawful for any person, think association there, to refuse to make reasonable accommodations in rules, policies, practices, or services when the accommodation is necessary to afford a person with a disability equal opportunity to use and enjoy the dwelling. And that includes the amenities. Our accommodations are reasonable if they are practical and feasible. relax your rules, policies, practices, and services to allow seeing eye dogs, other service animals, etc., caregivers, if they're underage or otherwise problematic under your governance documents, things like that. Remember, not every requested accommodation has to be approved. An accommodation does not have to be approved if it is unreasonable, if it would impose an undue financial and administrative burden, or constitute a fundamental alteration of the housing program. So in theory, we don't have to approve every requested accommodation. So let's end with where a lot of fair housing programs start. Race, color, national origin, whether you're Canadian or not, just an example, whether you're from Sweden or not, from Iceland, Russia, China, Vietnam, whatever. Religion, we can't discriminate on either of these four things, whether you're male, female, or some other sex. Sexual orientation is protected. Gender identity is protected. Familial status, sometimes people ask, well, what does that mean? It means whether you're married or not. It means whether someone has a child or not. And those are the protected categories. So here are some of the things that come up, although it's not so much within the recent year or two. What about bathrooms? Do we have to be concerned about biological men going into the women's bathroom at the clubhouse? Well, some people are going to be concerned about that. Are they concerned about it because they're manufacturing problems, or is it a real problem? I've had clients where it's happened. And I have a wife and 3 daughters. I have 3 granddaughters. And when you're a man with that kind of, and 2 sisters and a mother who's still alive, and when you've got that many women that you love, the idea of a man going into the women's restroom when the women you love are in there, I think that the thought of that bothers most men. So we could manufacture a problem as a theoretical or hypothetical question, but then people combat that hypothetical question with, but how often does it happen? Statistically speaking, it happens rarely, but I have had a client where it happened, and the woman who was in the bathroom was very upset by it. But the practical solution is what? Put a security guard at every bathroom? The cost of that would be ridiculous. And what would that security guard do if we were even to indulge in the hypothetical? There's no way to monitor the biology of anybody entering the bathroom. So gender identity is protected. And so it would be nearly impossible to monitor the comings and goings of bathrooms. So there's no case law on this. There's never been a dispute nationally about these bathrooms that's created precedent or binding case law that I'm aware of. And we have CAI has a law seminar every year. We talk about the case law from around the country. Nothing's happened yet. Another modern question and problem is whether or not associations can or should solicit neighbor input on architectural matters. This is an important one because I did a seminar on hostile housing harassment in April of 2024, and it's still accessible on my website. And here's why it matters. If the association's habit is to say, well, there's an architectural request for Scott Carpenter's lot, let's call it Lot 18, Green Acre. And we always solicit input from the two neighbors on both sides and the neighbor behind. There's three people that need to weigh in a grid neighborhood at Greenfield and Guadalupe, let's call it. That is where I live. Let's just call it Greenfield and Guadalupe in Gilbert. And they're going to weigh in. Well, let's say that I'm not who I am. I'm not some white Caucasian guy. And my neighbors are racist. And, or maybe I am who I am. I'm a white Caucasian guy, and they're racist against me for that reason. And they are asked for input, and they decide to provide negative input because of their racism. Now the association is a party to the racism. They have allowed the association's architectural infrastructure to be co-opted by the racism of my neighbors. And my neighbors have done their housing harassment by simply providing negative feedback on my architectural application, and their racism was able to be exerted on me by the association's making itself available to their racism by simply providing negative feedback on my architectural application. So it's dangerous to ask for neighbor input on architectural applications. And it begs the question, if a neighbor can nuke my application by providing negative feedback because they're racist against me, because I'm purple, brown, black, Hispanic, Icelandic, Swedish, whatever, should we end the practice of getting board input from neighbors at all? And I sort of think we should. There's the hole is so big you can drive a train through it. The board has the obligation, and the architectural committee has the obligation to do its job to pass on architectural applications. Simply do it. We don't need neighbors to weigh in. There's too many opportunities for neighbors to bring too much to the table. Too many bad vibes. Stuff we don't know about at the association level. A problem between their kids, something that happened at the bus stop, something that happened at school. That has nothing to do with the architectural application. An insult lobbed by by the applicant's kid toward the neighbor's kid. We don't know anything about that. And now all of a sudden we're saying, hey, what do you think of this application? And we assume neutrality. We assume that it's on the up and up, that everything's as it appears. It's too complicated, frankly. Let's talk about harassment generally. Everyone is in at least one category all the time. I have a race, I have a color, I have a national origin. I have a religion, I have a sex, I have an orientation, I have a gender identity. I guess people call me cisgender. I have a familial status. I mean, think about that. I'm Caucasian. I'm white. I'm from America. I have a religion. I'm male. I'm straight. I identify as the gender I was assigned at birth. I'm a male. I'm married. I have 3 daughters. I mean, I've just basically told you everything about me. And I could be discriminated against on the basis of everything I just said, up and down the line here. Somebody could say, I don't like any of that stuff, and I'm going to discriminate against you based on everything you just identified about every single one of those things. And I'm open about all of it. And a lot of those things you could assume just based on by looking at me or knowing me for 30 seconds. So it's not all that complicated. So everyone's in at least one category all the time. I just told you I'm basically in all the categories. Every owner can say I'm being harassed because I'm in category X and the association has to stop the harassing conduct. I'd invite you to that other seminar if you're interested in more of that. We don't take questions all along the way, but I see there's one in the chat. I try to keep these to an hour. I didn't do very well with that. Little problem with the audio. I tried to fix that this time. Hopefully I did a little better. All right. Thank you all for joining me today. Hopefully this was helpful. And in October, I'm going to talk about assessment collections. The legislature keeps messing with that. And hopefully we'll have a good conversation when we gather in October. I've got some ideas, and hopefully we can make some progress on assessment collections in October. Thanks.